Chaliye, let's start with the session. We'll quickly revise what we did in the last session and then we can proceed further. We can start कर लेते हैं session को. We'll quickly revise what we did in the last session and then we can accordingly proceed further. ठीक है? Sir, looks like you have lost weight. Yes, I have lost, to be exact. I have lost 12 kgs in 2 months. तो मेरे लिए achievement है बहुत बड़ा. Especially considering the time. So, ठीक है. It was necessary for me. मतलब it was very necessary for me. In fact, I was getting overweight day by day. मेरा
डाइट बता दीजिए सर.
सही में सर प्लीज हमें भी बता दीजिए.
Diet is very cruel. मतलब बहुत ही cruel है. बहुत fasting है. It is really at first 5 days I felt like really sad. कि कुछ खाने को नहीं मिल रहा, but then I was so used to the diet that I enjoyed doing it. So now I don't feel the craving. But earlier, जब पहले 10 days थे, it was really sad. The diet is very simple. In morning, to be honest, I don't have any breakfast. I only have coffee.
So kindly use whiteboard, sir, please.
Yeah. इसके लिए diet के लिए ठीक है.
सर आप intermittent fasting कर रहे हैं क्या?
Intermittent fasting.
Okay.
Intermittent fasting follow कर रहा हूँ. So basically, तो सुबह में कॉफी, ओनली ब्लैक कॉफी, नथिंग एल्स. कभी कभी ऐसा हो गया कि मेरा ज्यादा ही मूड हो गया तो आई हैव 2 things टू क्रंच. एक रहता है कि एग्स एट टाइम्स, वो भी डेली नहीं करता. एट टाइम्स आई हैव एग्स एंड कभी कभी ये होते हैं प्रोटीन सीड्स जो होते हैं. You will have watermelon seeds and you have these बाकी के क्या नाम है इनका, watermelon seeds, flax seeds, chia seeds, pumpkin seeds, जो भी है मतलब जो भी you can हाँ वो प्रोटीन सीड्स, उनसे वेट भी गेन नहीं होता एंड यू मतलब आपका जो क्रंचिंग का आदत है दैट आल्सो इज इंटैक्ट एंड अच्छी चीज है, प्रोटीन ही मिल रहा है आपको. व्हाट एल्स यू वांट? ओमेगा 3 आल्सो. हाँ तो मटर नहीं बाबा, मटर तो खराब है. देन फिर उसके बाद डायरेक्टली आई हैव लंच एट अबाउट 2 PM और 2:30 और 2 to 3 आई हैव लंच. अब लंच सपोज आप 2x कर रहे हो तो डिनर आप 1x कीजिए. बीच में कुछ मत खाइए. बीच में यू डोंट हैव एनीथिंग इन बिटवीन. हाँ अगर आपका कुछ मूड होता है यहाँ पर एट हेयर समवेयर, कुछ लोग रहते हैं ना कि मतलब इवनिंग, मेरा तो था इवनिंग में आई यूज्ड टू हैव टी एंड कॉफी एंड आई यूज्ड टू हैव समथिंग अलोंग विथ इट एंड दिस हैपेंस. सो फॉर दैट यू कैन हैव अ प्रोटीन बार, एक छोटा सा प्रोटीन बार मतलब खा के, मतलब दैट इज ओनली फुलफिलिंग. एंड देन कम्स डिनर का एक टाइम फिक्स कीजिए, दैट कीप इट एट 1 टाइम ओनली. सो इधर यू वांट टू कीप इट एट 9 PM. जैसे मेरा तो अब 10 o'clock को मेरा लेक्चर खत्म होता है, सो आई कीप डिनर एट 10:30. सो एट 10:30 आई ईट डिनर एंड डिनर विल बी नो, ये 2x है तो ये होगा 1x. whatever you are having, suppose you are having say 4 rotis here, so you will have only 2 rotis here. You are having 8 rotis here, तो मतलब जितना भी है ये अगर 2x है तो ये 1x रहेगा अकॉर्डिंगली. क्योंकि डिनर को आपका प्रपोर्शन कम रखना है so that your fasting time is increased, because while you are sleeping you are not hungry, तो आपका फास्टिंग का टाइम इंक्रीज हो जाएगा. यहाँ पर तो आपका इच्छा हो कि रही कुछ ना कुछ खाऊं, बट यू आर स्लेप्ट. So it is the end of the game. So that is very sorted. तो ये मतलब ये मैंने फॉलो किया एंड इट हैज मतलब ठीक ठाक चल रहा है मेरा ये. एंड अलोंग विथ वर्कआउट, तो वर्कआउट के साथ ही है. ठीक है. आई डोंट कंज्यूम डेयरी. आई हैव स्टॉप्ड कंज्यूमिंग डेयरी. अर्लियर आई यूज्ड टू. नाउ आई हैव स्टॉप्ड कंज्यूमिंग डेयरी. डेयरी कभी इन अ फ्यू, मतलब महीने में एक बार हो गया तो मतलब कभी एक चीट डे पर डेयरी आई हैव, but otherwise I have stopped for the time being. For 3 months I have stopped dairy, then after 3 months I'll continue. I'll go on to dairy.
सर आप नॉन वेजिटेरियन चिकन मटन ये सब नहीं खाते?
हाँ नॉन वेज खा सकते हो ना, आप डिनर में नॉन वेज खाओ. ठीक है, डिनर के टाइम यू कैन हैव नॉन वेज. नॉन वेज इज द बेस्ट थिंग फॉर प्रोटीन. प्रोटीन में, और वेज में पालक, ऐसी अच्छी चीजें खाओ. डोंट ईट रबिश. फ्राइड अवॉइड करो. ट्राई टू अवॉइड फ्राइड थिंग्स व्हाइल यू आर हैविंग लंच. हैव गुड थिंग्स. पालक है, मेथी है, इतनी अच्छी चीजें हैं भगवान ने बनाई है. If you want to have chicken, if you are non-vegetarian, have chicken and fish. Fish बहुत ही best source है for skin, for protein, everything. Fish is the best thing. And if you end junk from your cycle, 50% thing is done. बाकी का आपका 50% चीज तो हो ही गया. बाकी छोटा छोटा things that you have to cover, that will get sorted. So ये है routine. ठीक है, अभी so far तो यही चल रहा है. Let's see how far it continues. अभी मैंने अच्छे से 2.5 months I have followed this rigorously, and so far it is good. मतलब for me it has worked wonder. काफी सारी चीजें कम हो गई mentally भी. मतलब things have started sorting. मतलब क्योंकि खाने से ज्यादा दिमाग भी वो होता है. You are usually confused. But when you don't eat things and you have controlled the diet, तो आपका दिमाग भी ट्रैक पर आता है, एक ही जगह पर काम करता है. It is not working in various places. So ऐसा है. ठीक है, तो ये है. So this is what my regime is. चलिए, now come, let's study now. यहाँ तक क्लियर हो? क्लियर हुआ था? क्लियर? आगे बढ़े?
Yes, sir.
चलो.
Yes, sir.
Yes, sir.
Thank you, sir.
चलो, आगे बढ़ते हैं. Now let's understand. बाकी बॉडी बिल्डिंग करनी है, उसके लिए ये रेजिम नहीं है. You will have to consume a lot of things. अगर आपको अहमद लोग पूछ रहे हैं, आप लोग को तो बॉडी बिल्डिंग करनी है, आप लोग ये कहाँ, you will have to consume a lot of calories. You guys will have to, अहमद नगर आप लोग तो कंज्यूम करते होगे. You guys must be consuming a lot of calories, ना? चलो, लीन प्रोटीन. लीन के लिए ये है, बॉडी बिल्डिंग के लिए नहीं है. इफ यू वांट टू गेट लीन एट द फास्ट, तो यही. ठीक है, तो लेट्स स्टार्ट विद द सेशन. देन कम, हमने 3 चीजें we did yesterday. We did 2 things. So first we went on to understand. I told you we have started with something known as privileged communication. So I told you exactly what is privileged communication. So privileged communication is basically communication. There are 3 forms of privileged communication. Broadly, there are 3 forms of privileged communication, and I have told you that there can be more forms also. उसमें से first form is communication between husband and wife. That is matrimonial communication. That is communication between husband and wife. And the second is communication, that is official communication between governments. And then comes the third part, that is attorney-client privilege. Now I told you that matrimonial communication is provided in section 122. Section 122 में matrimonial communication provided है, and we went on to discuss 122 at a length. I told you that basically what happens that if there is a communication between husband and wife in the course of marriage, then it cannot be, the husband and wife cannot give evidence against each other, and ultimately they cannot be compelled to give evidence, and they cannot voluntarily also give evidence. So both the things are, either they cannot willfully give the evidence or they cannot voluntarily also give the evidence. So these are the 2 things that we went on to understand. And then I told you, even if the marriage ends, then also the privilege will remain, and even after end of marriage, they cannot give evidence against against each other. Neither they can be compelled. So the privilege does not have any relevance with respect to the continuance of marriage. If the marriage has terminated, if the marriage has ended, then also privilege will remain. Now, then I told you that if there is a communication which is made before the marriage and after the marriage, in that case, 122 will not apply. In such cases, 122 will not apply, and you can use communications you can give these communications in evidence. I told you what is the purpose of this. I told you the purpose is to maintain the harmony in the family, to ensure that there are no brawls in the family, and to ensure that there is the relationship of trust and faith between husband and wife is maintained. These are the things for that we have introduced this privilege. Now comes the exception of this privilege. In what cases husband and wife can give evidence against each other. So the first is waiver of privilege. First is waiver of privilege when if the person who made the communication, if suppose husband made the communication and he has waived his privilege, he said that, okay, fine, I have made this communication to you, but if you want to give it in court of law, you can give it. So if he expressly waives the privilege under 122, in that case, the communication can be disclosed. But if that privilege is not waived, then communication cannot be disclosed. So first is waiver of privilege. So these are exceptions to 122. जब मैं बोलूं exceptions to 122, in these cases, exceptions to section 122, कहने का मतलब है in these cases, यहाँ ब्रैकेट पे लिखिए, in these cases, communication between husband and wife can be disclosed. Between husband and wife can be disclosed. Husband and wife can be disclosed. In these cases, एक second, in these cases. Okay. In these cases, communication between husband and wife can be disclosed. Husband and wife can be disclosed. Can be disclosed. ठीक है. तो उसमें पहला है waiver of privilege. First is waiver of privilege. ठीक है. Now, waiver of privilege is that if the person who made the communication or his representative in interest consents that the communication can be disclosed. So if the person who made the communication or his representative in interest consents, the communication can be disclosed. Can be disclosed. ठीक है. अब यहां पर प्रॉब्लम है, देखो, पर्सन तो ठीक है, पर्सन आई अंडरस्टैंड, पर्सन you guys also understand, the person who has made the communication. For example, a husband told his wife that whatever communication has happened between us, you can disclose in court of law. So the person who is making the communication has authorized or waived his privilege. But how can a representative waive the privilege of the person making the communication? मान लो husband communication कर रहा है. Husband has told the wife that he has taken loan of 1 lakh rupees from X. ठीक है, he has taken loan of 1 lakh rupees from X. ठीक है, X से loan लिया है 1 lakh rupees का. Now this is a communication. Now ideally 122 applies. Ideally wife cannot disclose this communication in court of law. She cannot voluntarily also, she cannot be compelled also. दोनों भी चीज, ठीक है. Now if husband says that I am giving you the authority to disclose because since X is your good friend, I am giving you authority to disclose, you can disclose in court of law. Now this is the person who is making the communication is allowing you to disclose. Now what about representative in interest? How can representative in interest give the authority to disclose? Now what is a representative? पहले तो husband का representative कौन होगा? Husband का representative, मान लो if the husband dies, who will be the representative?
Wife.
Son भी रहेगा और wife भी रहेगा. Wife भी रहेगा. Son भी होगा. Suppose husband has a son, तो son होगा वो. मान लो husband के पास son भी है. Son भी representative होगा, wife भी representative होगा. Can wife waive the privilege on behalf of the husband? अब क्योंकि husband ने तो waive नहीं किया and husband has died. Now, since husband has died, can wife herself waive the privilege on behalf of the husband? Because the word that they have used is representative in interest. What I am trying to suggest is, will representative in interest include the other spouse, the spouse who did not make the communication but who heard the communication? Will representative in interest include spouse who heard the communication? बताइए. What do you think? रैशनल से हिसाब से बताइए, रैशनल के हिसाब से सोच के बताइए. Will it include?
No, sir.
It shouldn't. It shouldn't, because ultimate purpose of the entire thing will be dead if we have to include this. So, एक Bombay High Court में an interesting case had happened wherein husband had taken a loan from father-in-law. ठीक है? This is father-in-law. Husband had taken a loan from father-in-law and he had informed about the loan to wife. He had told that, see, I have taken the loan from your father and I have taken so and so money and this is the interest I have taken from him. And husband is not able to repay it, so ultimately he dies. Husband has not yet repaid and ultimately he dies. So now wife tells the son to actually repay the debt of father because son inherited the business of the father. So wife tells him to repay. So son says that I don't know that whether this debt actually exists. I have no knowledge of this debt. मुझे तो पता ही नहीं है कि ये कर्जा exist भी करता है. So wife tries to give information or tries to prove communication between them. Tries to give information or communication between them to court, between husband and wife. So whatever the communication happened between husband and wife regarding the debt relating to father-in-law, wife tries to give that evidence in court. Now the court says that we cannot take this. We cannot take this. We cannot take this testimony because it is barred under 121. You are not allowed to give this testimony without the consent of husband. Wife says that since husband is not alive, I am her representative. So in the capacity of as a representative, I can waive privilege on his behalf. Will you agree with this argument?
No, sir.
No, sir. Purpose is dead हो जाएगा. The purpose of the section will be dead by that logic. So one thing that you have to always keep in mind when we are talking about representative in interest, it means any person other than the spouse. So representative in interest will mean any person other than the spouse who received the communication. In interest means any person other than the spouse. Other than the spouse. Then the spouse. So ये तो हो गया waiver. So this is the first exception. In this waiver case में you can exclude. You can give evidence. Now comes when the suit is between married persons. 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 Okay. So when the suit is between married person, if the suit is between married persons, in that case, last part of section 122 will apply. Obviously, last part of section 122 applies. So if the suit is between married persons, they can give evidence against each other. There is no bar. So suppose the suit is between husband and wife. Say the suit is for recovery of property between both of them. There is a suit of property between husband and wife. They are claiming property from each other. In that case, they can reveal the communications that have been made between them in the course of marriage. In that case, bar of 122 will not apply. So, ये लिखिए कि last part of 122, last part of section 122. Last part of section 122 clearly provides that it does not apply that it does not apply when spouses are at opposite side. Spouses are at opposite side. As opposite sides. So consider there is a suit between husband and wife, or wife has filed a suit against husband for claiming stridan. हो सकता है ना, wife can file a suit against husband for claiming stridan. In that case, all the communication that have taken between them, wherein husband says that yes, this property belongs to you, I will give you back your stridan whenever you need, etc., etc. This is your absolute property. So all the communication wife can use against the husband. She won't be barred by section 122. Section 122 in such case will not apply. So this is suit between married person. What about criminal proceedings? If one party, if wife is the informant or husband is the informant, then one spouse is being prosecuted for crime against the other. What if one spouse is prosecuted for crime against the other? In that case, will 122 apply? Suppose wife has sued, wife has filed a criminal proceedings under 498A. अब जितने लोग प्रैक्टिस कर रहे हैं, आप लोग तो पता ही है कि कंप्लेंट में क्या क्या लिखते हो, क्या क्या चीजें लिखते हो कंप्लेंट में.
Sir, it won't apply.
Yes, sir.
पंखा मुझसे साफ कराती थी वो, हस्बैंड बोलते थे पंखा साफ करो, और इससे मुझे बहुत ही दुख हो गया उस दिन, एंड आई गॉट एनरेज्ड. मतलब बहुत सारी चीजें वैसे लिखते हैं. दिस इज वन ऑफ देम. सो बेसिकली when one spouse is being prosecuted by another, when one spouse is being prosecuted by another, is being prosecuted by for crime, one spouse is being prosecuted for crime committed against the other, then 122 will not apply. Then 122 will not apply. 122 will not apply. This is the third exception. ये है third exception. Then comes proof by third person. If a third person has heard the communication, in that case also 122 will not apply, because 122 is again a privilege to married persons or married parties. It is not a privilege against the third person. So if the third person has overheard the conversation or eavesdropped the conversation, in that case 122 will not apply. He can give evidence of that communication. You cannot claim the prohibition under 122. तो ये एक आपको समझना पड़ेगा. This is proof by third person. Proof by third person. Proof by third person. The privilege is between parties. The privilege is between parties. Privilege is between parties to the marriage, and no other. And no other person. And no other. Thus, communication taking place in presence of third person may be proved. Thus, communication taking place in presence of third person. In presence of third person. Person may be proved. If the communication is overheard by third person. If communication is overheard by third person, it can be proved. ठीक है, तो ये है प्रूफ बाय थर्ड पर्सन. अब आ जाइए इस पे. एक बहुत ही इंटरेस्टिंग केस है. देयर इज अ वेरी इंटरेस्टिंग केस ऑन दिस वन. द केस
सर फर्स्ट लाइन में क्या लिखा है?
The privilege is between parties to the marriage and no other. Other 2 बार हो गया. Yes, भावना बोली.
थर्ड पर्सन मतलब उनके डॉटर सन कोई भी
डॉटर सन कोई भी फादर इन लॉ कोई भी. सो सबसे इंटरेस्टिंग केस है इस पे, दैट इज MC वर्गीस वर्सेस TJ पूनम. MC वर्गीस वर्सेस TJ पूनम This is 1970 Supreme Court. Now अब इसमें क्या हुआ था? There were letters written by husband. Husband had written certain letters, and in letters he had defamed his father-in-law. Father-in-law के बारे में बहुत सारी गंदी बातें कही थी. But these letters were not addressed to father-in-law. These letters were addressed and they were sent to wife. So these letters were sent to wife. Now what happened? Father-in-law found these letters one day. And he read these letters. So he filed a defamation case against husband. Okay, father-in-law कोई letters मिले, so he filed a defamation case against husband. ये जो अपने मतलब उनके son-in-law के लिए against, he filed a defamation case. So he filed a defamation case. Husband said that, boss, this is a communication between husband and wife. This letter you cannot present in court of law. This will be barred under 122. You are not allowed, and you cannot be compelled also to produce this letter. You cannot be compelled, and you are not allowed also. Both the things. So this letter is basically barred from being produced. This is what husband claimed. Husband ने बोला कि बस ये letter तो आप नहीं prove कर सकते. That he took a defense that it is barred by 122. Now here, what do you think? Will it be barred? क्या लगता है?
No,
Will it
sir.
be barred?
No, sir.
It will not be barred.
See, the court held that bar will only apply if wife is called as a witness. So, and the bar is only applicable to husband and wife. It is not applicable to a third party. So in this case, since father-in-law has procured the letter, he can give evidence of the letter, and he can also produce the letter. It will not be barred. So bar applies between husband and wife. Bar applies to husband and wife from asking questions to them, or when they are standing at the stands. Bar does not apply on any other material. So if any other person has heard any information, they can give evidence. They can certainly give evidence. तो ये है MC वर्गीस वर्सेस TJ पूनन. तो इसके फैक्ट्स ऐसे थे कुछ. पहले तो फैक्ट्स ये था कि letters were written by husband to wife. Scary father-in-law ना. Imagine करो, ये भाई साहब ये defamation complaint लेके 1970s में he went to Supreme Court. When during that period going to Supreme Court was the most expensive thing. Rarely matters were listed in Supreme Court. सिर्फ defamation का केस लेके, और कोई ऐसा भी नहीं कि चोरी चकारी मार झार कुछ नहीं. Yes, we have done this case in IPZ, correct.
सर कहीं आपके साथ ना हो जाए सर. इंडिया पाकिस्तान का मैच होते रहता है.
इमेजिन करो, मतलब ऐसा कितना खतरनाक फादर इन लॉ होगा. इमेजिन करो. तो ये है कि लेटर्स रिटन बाय हस्बैंड टू वाइफ. तो इसके लिए ऑलवेज रिस्पेक्ट योर फादर इन लॉ. सो लेटर्स रिटन बाय हस्बैंड टू वाइफ contained defamatory matters about father-in-law. ठीक है. Father-in-law brings defamation. Father-in-law brings defamation case and intends to bring letters as evidence. evidence. Yes, defamation should be in public, and that is the reason son-in-law was acquitted, but evidence was taken. ठीक है. Defense था कि it is barred under section 112. Production of the letter is barred under section 122. So production of letter is barred under section 122. Court held. Now this is the defense, and this is what the court held ultimately. This is what the court held. That bar would apply. Bar would apply only when wife is called. Only when wife is called as witness. Only when wife is called as witness. As witness. Okay. So bar applies only to husband and wife. Bar applies only to husband and wife and not to third person. Applies only to husband and wife and not to third person. And not to third party. Third party. Okay. Now this case was inspired from a British case. ऐसा नहीं था originality थी. This was inspired, but that was slightly more grave. इतना छोटी चीज नहीं हुई थी उसमें. उसमें there was a husband. He made a confession. He sent a confessional letter to his wife. In that letter, he admitted that he has committed the murder of so and so person. And he gave that letter to colleague, and he told the colleague to give it to his wife. Colleague went and gave this letter to court as evidence. Husband said that I had addressed this letter to wife. Why I have addressed this letter to wife? You cannot use this letter. This will be barred under 122. The court in this case held that this evidence will be admissible because it has been brought up by a third person. Since there is a third person involved here, thus evidence will be admissible. So this was Rumping versus Director of Public Prosecutor 1964. ये 1970 का है. 6 साल का ही फर्क है दोनों में. That matter was slightly grave, but the reasoning in both the cases is same. In fact, logic भी same ही है. ठीक है. अब आ जाइए Rumping versus. It is Rumping versus. This is the case. Rumping versus. एक second. Rumping versus Director of Public Prosecutor. Public Prosecutor. That is 1964. एक husband थे. He had confessed murdering someone in a letter. And he had sent that letter to wife. He sent that letter to wife through a colleague. So, okay. Now, colleague produces this letter as evidence in court. Colleague produces this letter as evidence in court. Bar of matrimonial privilege will not be applicable. Bar of matrimonial privilege will not be applicable because the proof is not applicable because proof is by
Third person.
because proof is by third person. Proof is obtained from third person. Third person. ठीक है. तो ये है रम्पिंग वर्सेस डायरेक्टर ऑफ पब्लिक प्रोसिक्यूटर, एंड देन कम्स द लास्ट एंड द मोस्ट इंटरेस्टिंग थिंग, and this changes the dynamics of 122. Now see, you cannot give evidence of communication, correct? You cannot say that my husband said me this and he told me this, but wife can certainly testify about the conduct of the husband. Now Supreme Court for the first time held this in Ram Bharose versus State of UP 1954, wherein husband had committed a robbery. And after committing robbery, and he had committed the robbery from neighbor's house, and after committing robbery, he had killed the neighbor also, he has committed robbery. And after committing robbery, he comes to wife and he gives her all the stolen goods, all the stolen material, and he keeps all the stolen material in front of her. Now, wife testified that husband showed me the stolen material and husband went outside the house. This is what wife testified. The husband claimed that she cannot testify this because she is barred under 122. Court here held that the bar of 122 is not applicable on testifying conduct. You can give testimony as to conduct. आप conduct की testimony दे सकते हो कि मेरे husband ने ये किया. This is what my husband did. You cannot give testimony as to the communication कि मेरे husband ने ये बोला, उसकी testimony नहीं दे सकते. You can give testimony of the conduct, at what time he left, at what time he came back, what all happened. You can give testimony of all these things, but you cannot give testimony of communication. So 122 is only barring communication. Now, interestingly, this interpretation of the section makes section slightly redundant. अगर आप देखोगे ना, ये interpretation अगर हम follow करें, so section will be slightly redundant, but this is how we will have to follow the interpretation, because this is where they have clearly drawn the line. They have only barred communication. They haven't barred any other aspect in 122. And in fact, that is the reason we are talking about now. These are privileges as to the communication. All the three privileges, तीनों भी privileges are as to communication or words. They are not privileges as to the conduct of a particular party. So conduct, though, you can give evidence in all three. So this is what makes the game more interesting. So these are acts apart from communication.
लेकिन सर पर्पस तो डिफीट हो रहा है ना, फिर रैशनल जो है वो तो डिफीट हो रहा है ना.
रैशनल डिफीट हो रहा है, बट प्रिविलेज है ही बात के लिए ना. प्रिविलेज आप एक्ट के लिए है ही नहीं. कोई भी, तीनों भी प्रिविलेजेस नहीं है, तो उससे रैशनल इतना डिफीट नहीं हो रहा. वरना ऐसा हो जाएगा कि कोई भी एक्ट कर रहा है हस्बैंड, तो वाइफ सिर्फ देखते ही रहना है. ऐसा नहीं होना चाहिए. दिस शुडंट बी द केस ना. ठीक है. सो शी कैन गिव एविडेंस एज टू एनी एक्ट अपार्ट फ्रॉम कम्युनिकेशन. तो कम्युनिकेशन छोड़ के बाकी सब कर सकती है. ठीक है. यस अहमद, बोलिए.
Sir, what about the communication that discloses our conduct?
What are conduct?
Sir, what about the communication that discloses our conduct?
No, that communication cannot be used. That communication cannot be used. It's a complete bar on communication.
Conduct, sir.
Even if it is along with conduct. मान लो उसके साथ आता है, बोलता है कि मैंने ये चोरी का सामान लाया. So she cannot give as to the evidence that उसने ये बोला कि मैं चोरी का सामान लाया. She can give evidence that he brought some things, बस. ठीक है. Along with or preceding उसका नहीं दे सकते आप. That is a complete bar on communication. ठीक है. तो ये है acts apart from conduct. This is acts apart from communication, जिनको बोलेंगे हम conduct. Acts apart from communication, which we can call conduct. So wife can testify as to what husband on one particular occasion did. What husband on one particular occasion did. What husband on one particular occasion did. On one particular occasion did. occasion did. Though she cannot testify what she said to her, what he said to her or she said to her, though she cannot testify what she said to her. What she said to her. Now this entire thing was held in one case, that is Ram Bharose versus state of UP. This is a major opening in this section. Malab, this is a major loop that is found in this section, and this is the most important loop, and this is the loop that is channelized while taking a defense or while examining a witness who is a wife. तो ये है राम भरोसे वर्सेस स्टेट ऑफ यूपी 1954. तो इसमें सिंपल था कि H was accused for murdering neighbor and robbing him. ठीक है. अब वाइफ कैन टेस्टिफाई. अब वाइफ क्या क्या टेस्टिफाई कर सकती है इसमें? वाइफ कैन टेस्टिफाई at what time he left. Communication तो नहीं है, time can be seen ना. Time he came back. At what time he came back? At what time he came back? Third, wife can testify where he went if she has seen him. She has seen him. ठीक है. And wife testified that he presented ornaments to her. Right after he came back. So this was wife's testimony in this case. ये सब चीजें बताई. और वाइफ ने कहीं पर भी ये नहीं बताया कि husband has communicated this. Wife said that I saw the time at this time he left. I saw the time at this time he came back. And I also saw where he went. He entered the neighbor's house. When he came back, he presented me the ornaments. ये चार चीजें wife ने बता दी कोर्ट में. Other than communication, wife has told the entire conduct of the husband. Now this is what wife has testified. This is what wife has testified. Wife's testimony लिख दो. ठीक है. This is what wife testified. So this is wife's testimony. Now, court held that this testimony is reliable and this can be taken into consideration. This won't be barred by 122. So court ने held किया, this testimony will not be barred by 122. Barred by 122. Section 122 as wife, as spouse could testify as to conduct ठीक है. This is what is under 122. तो ये है आपके 5 exceptions. These are your 5 exceptions. ये exceptions कहाँ से आते हैं? आपके section read करने से आते हैं. Section में communication word है, conduct bar नहीं है. Section में exception में criminal और civil proceedings दोनों भी लिख दिया है. Section में clearly provided है that this is between parties. Third person की नहीं है. So this is on reading of the section only you can understand. Yes, Ando.
सर वैसे देखा जाए मतलब वैसे एक्सेप्शन बोल रहे हैं लेकिन सेक्शन में लिखा है साफ साफ कि ये है, बस इसको और कोर्ट ने और इलैबोरेट कर दिया है बेसिकली.
हाँ जी, कोर्ट्स ने टाइम एंड अगेन दे हैव इलैबोरेटेड. तो पहला है वेवर ऑफ प्रिविलेज. ये भी सेक्शन में ही बताया है. दिस सेक्शन में ही लिखा है. ये वेवर ऑफ प्रिविलेज सेक्शन में ही लिखा है ना कि if he expressly gives privilege. And then suits between married person. Suits between married person. This is also provided in section only. Then comes criminal proceedings. This is also provided in criminal proceedings between spouses. This is also provided in section only. Okay, criminal proceedings between spouses. Then comes proof by third person. Proof by third person. This is also provided in section only. And then there is last thing. Last hai acts apart from communication. Na? Communication. So these are exceptions under exceptions of section 122. Section 122. With this we are done with 122. अब आ जाओ 123 पे. Now come to 123. यहाँ तक clear हो? Till here you guys are clear?
Yes, sir.
ठीक है. अब आ जाओ 123 पे. Let's see 123. एक सेकेंड. एक सेकेंड. पहले सेक्शन पढ़ लेते हैं. Then we can understand what is it talking about. एक बार देखिए. Visible? चलिए. Now ये देखिए. No one shall be permitted to give any evidence derived from unpublished official records. No one shall be permitted to give any evidence derived from unpublished official records relating to the affairs of state, except with the permission of the officers at the head of the department concerned, who shall give or withhold the permission as he thinks fit. तो कहने का मतलब ये है, no one, no, मतलब this is to all persons. This privilege is against all persons. No one shall be permitted to give evidence derived from unpublished records relating to the affairs of the state. So कहने का मतलब है कि there are something known as unpublished records which are relating to the affairs of the state. And you are not allowed to give evidence against, produce these records as evidence. So there are something known as unpublished records. Unpublished records का मतलब है कि these records are not in public domain. These are not in public domain. ठीक है? These are not made public. These are kept as secret. These are not published. And these are relating to the affairs of state. And these are relating to affairs of state. Affairs of state. You cannot give evidence of these records without the permission of head of the department. So no evidence can be given of these records. No evidence can be given of these records without permission of head of department. Permission of head of department. Head of department. ठीक है? Now, head of department has the discretion to grant you the permission or not. That depends upon him. So this is what this is known as privilege in secrets, in cases of secrets or in cases of unpublished records. याद रख लो. Unpublished records. Now the question is, why are we not allowing them to be produced as evidence? The question is that. Basically, the answer to this is very simple. In order to protect public interest, these matters or these records are so essential for the security of nation or to ensure that integrity of the nation is maintained, that if they are revealed, then there will be disruption in the society and there can be a disruption in the country as a whole. So in order to avoid such a situation, these records are not published and these records are not made in public domain. So therefore, you cannot give evidence of this record also. Because if you give evidence, ultimately these records will come in public domain Public will get to know about them because court will be using these records in judgments, and they will ultimately be a part of the judgment itself. So in that case, what will happen ultimately? These records will be published, and it can be catastrophic for the entire nation also, because it can lead into wrong hands, as someone rightly has pointed out. It can lead into wrong hands, and someone might use them against us also. So the reason we are not allowing the revelation of these records or disclosure of these records is to ensure that there is public interest maintained, or there is public interest to ensure that there is public interest. For public interest, we are not disclosing. So for public interest, we are not disclosing. So no disclosure. So that there is public because ultimately what will happen if we disclose them, public interest will be adversely affected. So that we don't want to happen. So that is the reason we are not allowing disclosure of these documents. Okay. Now, disclosure of these documents can be permitted only by one person, that is head of the department. Now, who exactly is the head of the department? Now, you have various ministries. आपके पास various ministries होंगी, बहुत सारी various ministries होंगी. You must have seen that various ministries are there. Suppose there is a defense ministry. Now, who do you think is the head of the department of defense ministry? The head of the department of the defense ministry is defense secretary. Okay. Same is there is Ministry of Home Affairs. Who is the head of the department? The Home Secretary. Foreign Affairs, Foreign Secretary. So this is the permission is from the head of the department, that is secretariat level permission. So that secretariat level is giving you permission ki boss, you can produce these documents in court of law. We don't have any problem with this. In our opinion, these won't affect public interest. If their disclosure will not affect public interest, and aap de sakte ho, koi dikkat nahi. So in that case, you can give evidence. But if they particularly object, and they can object. Suppose you are producing a document in court and suddenly the head of the department comes in and he objects you. He tells you ki no boss, this is a record which is unpublished in nature. We haven't yet, this is not in public domain, and this is relating to the affairs of the state. And if it is revealed, ultimately it will adversely affect public interest, and it's better it is not disclosed. So the head of the department can also object disclosure of any such document also. तो ये सारा किस्सा है आपका broadly 123 के ऊपर. 123 has a close relationship with another act which was brought in by British, which has been misused from time to time and again. In India, to a certain level, it has become redundant. कभी-कभी use कर देते हैं मूड हुआ तो. That is known as Official Secrets Act, अगर आपको याद होगा. अब Official Secrets Act का भी यही है कि any person who publishes an unpublished record relating to the affairs of the state will be held liable under Official Secrets Act if the committee views that document to be a secret of the state. That is obviously the discretion of the committee. उनको अगर ये लग रहा है कि ये secret है तो liable करेंगे, नहीं तो नहीं liable. So Official Secrets Act mostly relates to liability. Disclosure, when it comes to disclosure in court of law, that is dealt under 123. तो आज हम Official Secrets पे ज्यादा बात नहीं करेंगे. We won't talk much about Official Secrets Act. We will focus only upon 123. ठीक है. अब देखो, what does unpublished means? पहले तो publish का मतलब क्या है? Anything that is in public domain. You are googling something and it is coming. That is published. That is in public domain. Means that is made public. Something which the government has made public, that is published. Na? So anything that is in public domain, that is published. Anything that is not in public domain, which is not has been made public by the government, that is unpublished record. If you are procuring through some other means and you are producing it before the government, then also it is doubtful, because then also the bar is applicable on you. आप मान लो चोरी करके लेके आ रहे हो, Defense Ministry के दफ्तर से you are stealing a document and you are coming to court, you are saying that sir, I have procured this document, I stole it in the last night. The court will tell you ki, is this document published? whether the defense ministry has published this document before the public at large. At any movement, anytime, you will say no. Second question, the court will ask you whether this relates to the affairs of the state. Now comes the question, affairs of the state. What does this mean? Affairs of the state का मतलब है कि will revelation of this document will affect the state in any manner, will affect the sovereignty, integrity and security of India in any manner. आप पढ़ते हो document, you say yes, it might affect. If I reveal this matter, probably it may go into wrong hands and probably someone might use against us. So the court will say, boss, take permission of the head department. Take permission of the head department जहां से लिया है आपने. So you will again have to go to the head department and you will have to ask his permission. If he says no, you cannot produce it in court of law. ठीक है, तो ये है पूरा unpublished record का scenario. So even if you have procured the document through some other means, then also you cannot use it. ठीक है, अब आ जाइए यहाँ पर. Now come to the interesting scenario. Now come to the interesting part. अभी इसमें बहुत कुछ है, रुको. Yes, Nuri, बोलिए.
Sir, is the section 123 also relates to something known as like matters of the police administration, or only to the like government and the cabinet secretary? मतलब वही पे.
नहीं, पुलिस भी तो गवर्नमेंट ही है. पुलिस का भी मैटर सब उसमें आ जाता है. All things are falling in this.
ठीक है सर. एडमिनिस्ट्रेशन का भी वो डेप्यूटी
एडमिनिस्ट्रेशन का भी वहीं पर आ जाएगा. स्टेट लेवल पे भी जरूरी नहीं है, सेंट्रल लेवल पे.
अच्छा सर, थैंक यू सर.
ठीक है, अब 123 का रैशनल क्या है? व्हाट इज द रैशनल? द रैशनल इज वन थिंग ओनली, सोलिस पॉपुलस एक्ट सुप्रीमा लेक्स. कहने का मतलब है पब्लिक वेलफेयर इज द हाईएस्ट लॉ. Yes, generally production of all documents is norm, but where public interest requires us to hide a particular document, we can hide it. So the basis of this is this maxim. So it is saying that if any document is of public interest and you feel that public interest might be injured because of publishing that document, in that case, we will not disclose. So in the interest of public welfare, these documents are not disclosed. The purpose is that why we are not disclosing this document. These are not disclosed because in the welfare, for the welfare of the public, we don't want public to be affected. We don't want public to be harmed at a large. So that is the reason we are not publishing these documents. Okay? Or we are not allowing these documents to be proved. So जब भी एक MCQ में you will always have a question on what maxim 123 is based. So this is the maxim on which 123 is based. That is solus populus est suprema lex. That is public welfare is the highest law, and this is something which has been provided in 123. कारण ये है कि what is the general rule? General rule is that you have to produce all the documents, but here you are not revealing, or you are not disclosing a document because you feel that there is an injury to public interest may be caused. So that is the reason in this case public interest is the highest law. So this is the rationale. Now comes the nature of prohibition. What is the nature of prohibition? पहले तो ये समझो कि this prohibition extends to everyone. Everyone का मतलब है, see, how was 122 acting? 122 याद है कैसे? 122 was between 122 किनके बीच में था?
Husband and wife.
Husband and wife.
Correct. And same is 126. अगर 126 जब हम पढ़ेंगे तब भी आप देखोगे कि it is between attorney and client. This prohibition is to everyone. मान लो one fine day गलती से आपके घर पे किसी ने unpublished record डाल दिया, and you ultimately want to prove it in court, you will be prohibited under 123. So this prohibition is applicable to extends to everyone. No person is exempted from this prohibition. ऐसा नहीं है कि third person can give evidence, only these people to whom communications are made. ऐसा नहीं, everyone is prohibited from giving evidence. Now, two important requirements are there. Whenever any such document is produced before the court, so the court will ask whether this document relates to the affairs of the state. पहली चीज आपसे पूछेगा कोर्ट कि बॉस whether this document relates to the affairs of the state. Affairs of the state का मतलब है कि if this document is revealed, will something happen? Will some disruption happen in the state? That means that it is basically relates to the affairs of the state. If this document is somehow revealed, if this information is revealed, will the proper functioning of the government or proper functioning of the mechanism or proper functioning of the government machinery will be disrupted? If the answer is yes, then it relates to affairs of the state. Second question that the court will ask, ki boss, listen, whether this document relates to unpublished official record, means that this is not published and it is official in nature. Official ka matlab hai ki it is made by the official authority, that is defense authority, the defense ministry, or a say particular police station in a society. So matlab it is made by an authority who has, it is made by a person who has the authority to make it. It is not it is not a flimsy document. It is an official document and it is unpublished. So if these two things are met, then the court will say, okay, fine, we cannot allow you to disclose. If you want to disclose, please give us the permission of head of the department. Head of the department, जहां से document आई है, head of the department का permission दे दीजिए. Now, interestingly, head of the department has an absolute discretion, either of giving the permission or withholding the permission. रोकने के लिए भी उनके पास absolute discretion है, and for giving the permission also there is absolute discretion. ठीक है? So अब देखो तीन चीजें हो गई. Court is what the court is seeing. Court is seeing that whether the document is affairs of the state. ये क्या document affairs of the state है? पहला है ये affairs of the state है. Affairs of state है. Second, it is seeing whether it is unpublished record. Unpublished record. तीसरा यहाँ, then it is asking for permission. Permission of head of department. Head of department. Now this person has absolute discretion. He can allow also, he can withhold also. Okay? He can allow also or he can withhold also. Now the question that arises is, suppose he withholds. Suppose he withholds. So can you examine his nature? Can you examine the nature of the document? Suppose the head of the department says that, sir, this document is privileged. I cannot allow anyone to give evidence of it. Now, whether the court has the power to review it, or if he says we'll have to just trust his word. मान लो वो खुद बोलता है कि sir, this relates to affairs of the state. This is unpublished record, and I cannot allow disclosure of this statement. So whether the court has the power to review it.
No, sir.
Problem ये है कि if we don't have the power to review it, so almost every government document will be withheld, will not be allowed to be proved. अगर हम ये बोल देना, अगर हम allow ना करें, हम allow ना करें, if we cannot review the document itself, कि whether actually it relates to affairs of the state or whether it is of unpublished records, then probably what will happen, they will purposely withhold every document. सरकार कोई document हमें देगा ही नहीं, and ultimately it will be a problematic situation. They will withhold all the documents by using this privilege unnecessarily. For that reason, government has the power of reviewing the document. Now, interestingly, now the question that arises is, the important question is, how will the government review? Now, the first thing that the government should do while it is reviewing the document is, first the government will ask for an affidavit from the head of the department. head of the department will give the affidavit ki how this document relates to affairs of the state, how this document is unpublished nature, of unpublished nature. तो पहले आपका head of the department आएंगे, वो affidavit देंगे. Now, if the court is not satisfied with the affidavit, court बोला यार हमें मजा नहीं आया affidavit में, you haven't still proved that it relates to affairs of the state or it is an unpublished record, you still haven't proved that how will it affect public nature. So we can ask for another affidavit. Now, along with this affidavit, we can call the head of the department in court. And this is the most interesting thing. Head of the department को आप court में लेके आ रहे हो for examining, for cross examining. ठीक है? And then even after cross examination you are not satisfied, you will ask additional evidence. Show us additional evidences through which you believe that this document relates to affairs of the state. ठीक है? अभी तक हमारे हाथ में document नहीं आई है. Mind you guys, we haven't received the document because this fellow has withheld. हमें हमारे हाथ में अभी तक document नहीं आई है. हमारे हाथ में affidavit है. We got further affidavit. We cross-examined the fellow. We took additional evidence. अभी तक document नहीं है. Even after additional evidence, we are not satisfied. मान लो after additional evidence, we feel that कि ये तो गोची है. This document is not privileged. They are just playing with us so that they should not they cannot produce this document. In that case, we will ask or we will inspect the document itself, the document in question. And this is a very interesting power which has to be examined at the last. पहले ही नहीं आप बोलोगे कि document देख लो, मुझे देखने दो. Let me see whether the document relates to affairs of the state or is unpublished record. पहले ही दिन पे नहीं बोलोगे. This will be the last, at the last this power will be exercised. And in that you will examine or inspect the document. You will inspect the document in camera. Means no one will be there in court. Only judges will be there. Judges will be inspecting the document, whether this document relates to affairs of the state, whether this document is an unpublished record, and whether the discretion exercised by the honorable head of the department is correctly exercised. It is judicial in nature. So ये सारी चीजें देख के, if you feel that the document is not privileged, you will mention in the judgment. If you feel that the document is very well privileged and it relates to a secret of the state and probably if it is revealed something wrong will happen, you will not even mention it in your judgment. It will be as if it did not take place. The inspection did not take place and it will be as if that the document did not exist. You will just write a small line in your judgment. Inspection was conducted. Full stop. Document is privileged. Full stop. Nothing more, nothing less. इससे ज़्यादा you won't narrate anything about the document. You won't say anything about the document. This is only in the last case wherein you are not happy with the affidavit. You are not happy with the further affidavit. You are not happy with the cross examination. You are not happy with the additional evidence. Last में you will inspect the document itself. Doc itself. अब एक बात बताता हूँ. ये हमेशा से पावर कोर्ट के पास नहीं थी. Court did not have the power to inspect the document itself. Whenever the head of the department used to ask for privilege, we used to give them. We never questioned anything. It is only when in Rajnarayan versus State of UP, an attention was drawn of the court to section 162 that we thought that inspection is necessary because as a blanket, people are using this privilege. Yes, Rafael is a good example and I will be taking that example अभी थोड़ी देर में. 2 cases पहले करने हैं, फिर Rafael करूंगा उसके बाद. Because I want you to understand the mechanism. ठीक है? यहाँ तक clear है? Till here you guys are clear?
Yes, sir.
Yes.
हाँ, Rafael में हम यहाँ तक पहुंच गए थे. By the way, we inspected the document. हम यहाँ तक पहुंच गए थे. Document was not held to be privileged. In fact, document was mentioned in the judgment itself. तो हम इंस्पेक्ट भी कर दिए और हमने प्रिविलेज फेल भी कर दिया. तो रफाइल तक हम ये 5वें पॉइंट तक पहुंच गए थे. तो ये देखिए. नाउ कम टू द एस्पेक्ट. ठीक है. Now comes, can court review whether the matter is subject to privilege or not? Yes. The court has a duty also and it has a right also, ki whether the matter in fact or the subject matter which they are trying to produce is privileged or not, whether it falls under the domain of 123 or not. Now court will first examine the validity of the claims without looking at the document. You are not first supposed to look at the document. In certain cases, the court will have to order disclosure of document. In certain cases, now if the court is not satisfied with the document itself, is not satisfied with other evidences, in that case, court will have to order disclosure of document. But pehle court will answer the claim without looking at the document. Court will not look at the document. आपको सिर्फ उनके evidences लेने हैं about the document. You're not supposed to see the document itself. ठीक है. अब relationship between section 123 and 162. अब आप एक बार 162 पे आ जाइए. Come to 162. Come to 162. Are you guys on 162? 162 पे हो?
यस सर.
ठीक है.
Yes, sir.
एक सेकेंड, आ जाइए 162 पे. अब देखिए, production of document. A witness summoned to produce a document shall, if it is in his possession, bring to court, notwithstanding any objection which there may be to its production or its admissibility. The validity of such objection shall be decided on by the court. The court, if it sees fit, may inspect the document unless it refers to the matters of state, or take other evidence or to enable it to determine on its admissibility. 162 क्या बोल रहा है? 162 is simply saying that suppose if there is any matter, if the court has ordered production of any document, मान लो court has ordered production of any document, so and the person has an objection to it. Person says that I have, the document is privileged, or any other objection he has. He will have to bring the document and then he will have to object it in court. And the court will decide the validity of the objection. Court will decide whether the objection is valid or invalid. ठीक है? But when it comes to matters of state, it is not necessary for the matters of state. When it comes to matters of state, it is not necessary that in all matters of state, court has to inspect the document only. अब उसका कारण ये है कि if the court inspects the document in the matters of state, it will be a problematic situation. We will be going against the concepts of separation of power. We have to respect the executive also, no? So if we just allow a blanket inspection of all the documents itself, so it will lead to a problematic situation. So whenever there is a matter of state, we should first look for other evidence, and in the end we can inspect document itself, because it is not a prohibition. ऐसा कहीं मना नहीं है कि आप inspect नहीं कर सकते. Because here also they have written if it sees fit, unless it refers to a matter of state, or take other evidence to determine. So the court can inspect also. It is not a prohibition as such. तो ये समझो कि section 123 जो हम पढ़ रहे हैं, that has to be read with 162. 162 generally provides that when a person has been summoned to produce a document, he should produce the document even if he has objection. अगर उसके पास objections भी हैं, फिर भी वो produce करेगा. Fine. Now the court will decide the validity of the objection. Court will see whether the objection is actually valid. So on conjoint reading of both of them, it is clear that final decision whether the permission should be granted or not should be with the court. So it is with the court whether the document is privileged or not. It is the actual permission is with the court. Now court may inspect the document also, but court may not inspect as a matter of routine. Not a matter of routine. Not a matter of routine. Not a matter of routine, but in remote cases or last resort. जब कुछ मिल नहीं रहा तो डॉक्यूमेंट ही ले लिया, तब जाके. So this is what the relationship is. ठीक है, यहाँ तक क्लियर यू गाइस आर क्लियर? यहाँ तक क्लियर हो?
Yes, sir.
Yes, sir.
यस सर।
अब आगे बढ़ते हैं, एक सेकेंड। अब जो मैंने आपको पूरा लिस्ट बताया ना, एफिडेविट सारी चीजें, द एंटायर डायनामिक्स जो मैंने आपको बताया, दैट वाज हेल्ड इन स्टेट ऑफ पंजाब वर्सेस सुखदेव सिंह सोधी 1961 सुप्रीम कोर्ट, जहां पर उन्होंने बोला था कि whenever there is a privilege claimed, so when the claim of privilege should be made generally by minister in charge or secretary of that department in form of affidavit. So जैसे डिफेंस मिनिस्ट्री का डिफेंस मिनिस्टर विल मेक द एफिडेविट, ठीक है, और सेक्रेटरी ऑफ डिफेंस विल मेक द एफिडेविट. व्हाई सेक्रेटरी एंड डिफेंस मिनिस्टर, व्हाई नॉट द लोअर ऑफिसर्स? ये मुझे बताओ. व्हाई दीज गाइज आर क्लेमिंग प्रिविलेज? सेक्शन पढ़ के बताओ मुझे. व्हाई दीज गाइज आर क्लेमिंग प्रिविलेज? व्हाई नॉट
हेड ऑफ द डिपार्टमेंट.
Head of the
हेड ऑफ द डिपार्टमेंट।
Secretary State or Defense Minister, head of the department, and these guys have to file an affidavit. Now, if the court feels that the affidavit is unsatisfactory, court को मजा नहीं आया affidavit में, court can ask for further affidavit. In some cases, और ये है, Rafael is one of the case in which Minister of Secretary concerned can be summoned to face cross-examination on relevant points. You can summon the minister or secretary. Minister or secretary concerned can be summoned to face the cross examination. ठीक है. अब एक बात हमेशा से याद रखना, your affidavit should have a clear cut answer as to why do you feel that disclosure of document will injure public interest. It should have a clear cut brief answer. It should not be a general answer. Oh, it will result in sovereignty. Why? What is the essential threat that you are seeing? From which country, or what is the essential threat from where you are seeing? That should be it. And then comes the fifth. Court will ultimately hold a preliminary inquiry into the character of the document. And for this, court can ask for other evidence. ठीक है. तो अब यहां पर क्या क्या देखा हमने? स्टेट ऑफ पंजाब वर्सेस सुखदेव सिंह सोधी में क्या क्या चीजें देखी? एफिडेविट, पहला एफिडेविट देखा, फर्दर एफिडेविट देखा. एफिडेविट, and affidavit should have a brief saying that why it will injure public interest. It will injure public interest. ठीक है. And then further affidavit के बाद you will ask him for cross examination. After cross examination, then you will call for preliminary examination. May you will call other evidences. यहां पर other evidences लोगे ना, other evidences. अभी तक have we inspected the document itself? Are we inspecting the document itself? अभी तक हमने देखा है document?
नो सर।
No, sir.
We haven't seen the document itself. So this is what सुखदेव सिंह. अब सुखदेव सिंह सोडी ने एक बहुत ही इंटरेस्टिंग बात कर ली, which is no longer a correct law, but it was held in Sukhdev Singh Sodhi, and this is what was held, that court will not inspect document in any case. This was held in Sukhdev Singh, but at present this is overruled. And this has been overruled by State of UP versus Rajnarayan. State of UP versus Rajnarayan said that if the court is not satisfied with anything, then it can ultimately inspect the document itself. And if it finds that the document is not falling under the criteria of privilege, it is innocuous, it can order disclosure of that part. What is the harm in seeing the document? ऐसा क्या हो जाएगा? What will happen? But now, obviously, when you are seeing the document, you will have to follow certain rules. So those rules were also propounded in this case. So ये वाला जो last part है, this bar pronounced by Sukhdev Singh on viewing the document is overruled by स्टेट ऑफ यूपी वर्सेस राजनारायण, ये केस में आपका ओवररूल हो गया, ठीक है। यस अकीला बोलिए, यस अकीला से।
Sir, on section 162, the second para says that court may inspect unless it refers to matter of state, right?
Yeah.
So it clearly exempting the documents which refers to state of affairs.
Yeah, but you can inspect. That is not a this is not a blanket scenario because it has been used, na, if it sees fit. So it is already a discretion of the case to inspect. So this is not a blanket, or this is not a we cannot say that this is this prohibition is a complete prohibition. This is a partial prohibition. This section, this para 2 is not a complete prohibition. Okay?
Okay.
Para 2 is not completely prohibiting you. There is a partial prohibition that in last resort you can. Fine.
Okay, but
Because the
in
para
case of
yeah.
in case if it is asked in MCQ,
You can inspect.
we can say that
123 says that you can inspect. But if they specifically relate to matters of state, then you can say that no. If they specifically the question relates to 162, you can say no. Okay.
Okay, sir.
Fine.
Thank you, sir.
Now comes yes, Noori.
So, when the court is not satisfied with the first affidavit, second affidavit, then cross-examination plus additional evidence, so the court can see the document itself. And if it is satisfied, then the court will produce this report, right, sir?
Correct.
Then inspection was conducted, and then they will say document is privileged, right, sir?
Privileged or not privileged? Okay.
Sir, either of the two?
Either of the two, जो भी हो सकता है,
Right.
ठीक है.
Thank you, sir.
अब देखो.
Sir, are these 5 steps
अरे
mandatory to
रुको तो
follow?
आगे बढ़ने तो दो. These 5
okay.
अभी बहुत बाकी है, रुक लो. अभी इतना इंटरेस्टिंग चल रहा था, अभी आप सबने रोक लिया. अब रुको, अब मैं कहाँ था? ठीक है. I told you that this last part has been overruled. Court will not inspect है. Now the court can inspect. In the last resort, court can inspect, and there is no such prohibition as such. Court will be allowed to inspect. Court can check the document for its for whether it is actually privileged or not. The court can see. Okay. Now, this is something which was held in state of UP versus Rajnarayan, and the court said that if the court is not satisfied with the reasons, so the court may inspect the document. Now, the court said that एक कोर्ट ने बहुत ही अच्छी चीज बोली कि whenever we are asking for public interest. Now, public interest, there is a public interest in withholding, but now there is a public interest in also administration of justice. So both the public interest have to be weighed while we are deciding such a case. So there are two public interests. One public interest which is saying that don't use this document, withhold it, which is 123 privilege. And the other public interest is that allow production, and because a case needs to be proved. So both the public interest have to be weighed together, and which one is more, you will have to see. Court will have to have access of all the relevant materials to decide whether a particular document is privileged or not. We cannot just rely upon what the head of the department is saying. अगर वो करने गए तो हो चुका. So this is what was held in state of UP versus Rajnarayan. ठीक है, यहाँ तक क्लियर? क्लियर हो गया था? क्लियर
सर?
ठीक है. अब now अभी यहाँ पर ये नहीं बताया कि how do we inspect the document. If we are inspecting the document, this document is of such a nature which might be a state secret, which might affect the country itself, which might affect various people. How do we inspect this document? ऐसे थोड़े खुले में आप पढ़ लोगे. You will just start reading the document in front of all the advocates. That is not how you are supposed to do. Whenever you are inspecting this document, you are to inspect this document in camera. You are to remove parties outside. You are to take everyone outside. In fact, in in Rafael case, when this document was examined, it was examined in a sealed paper. All the parties were sent outside of the courtroom and they examined the document. Only judges were sitting, 3 judges were sitting, and they only read the document and they saw, and then they called the other parties. So you have to conduct such an inspection in camera. You cannot conduct an inspection in front of public. Fine. Now this was something which was held in RK Jain versus Union of India. अब एक केस है, ये कर लेते हैं, फिर मैं आपको एंड में बता दूंगा. अफेयर्स ऑफ स्टेट का मतलब पहले बता देता हूँ. ठीक है, यहाँ तक क्लियर हो गया? क्लियर
सर? वो इंटरप्रिटेशन दिखा दीजिए कि वन
कौन सी?
इंटरप्रिटेशन विथहोल्डेड. सर वो ब्लू कलर वाला अभी जो आपने दिखा था,
ये वाला.
सर. हाँ सर.
There are two public interests, na? Public interest versus public interest. There is public interest in withholding, but there is public interest in allowing also. You'll have to weigh both the public interest. ठीक है? Fine. Public interest in allowing is that the case needs to be proved. Clear यहाँ तक? ठीक है?
Yes, sir.
Yes sir.
अब affairs of the state का मतलब क्या है? Now see, affairs of the state is not capable of definition. What affairs of the state means? This word has been used in 162 also. अगर आप देखोगे. Now the reason we are inspecting, see, Akila has rightly pointed out, sir, when 162 is clearly prohibiting us from inspecting, why we are inspecting? 162 prohibits inspecting those matters which are affairs of state. But what if we are actually conducting the inspection to understand whether the matter is affairs of state or not? We cannot just rely upon his statement, na? We are conducting inspection for understanding whether the matter is actually affairs and state or not. So the basis of the inspection is whether the matter is actually affairs of state or not. Now, what exactly affairs of state means? See, you cannot define what is capable of. It is not capable of definition. You cannot define. But you can say that if proper functioning of a state or its machinery would be affected by disclosure of this document, then you can say that this document has the status of document relating to affairs of state. If you feel that proper functioning of the state or machinery would be affected with the disclosure of the document, then such document may also, then such document has the status of affairs of state. ठीक है? Clear? You guys are clear?
Yes sir.
ठीक है?
Yes sir.
Yes. अब एक आ जाओ. Now come to the last part. Now, for example, what are other affairs of state? So example है जैसे secrets of state. These are affairs of state. Confidential official communications are affairs of states. Documents between governments and its officers are affairs of state. State papers are also affairs of state. Okay, these are state papers, means communication between states. That is, communications between states are also affairs of state. Communications on certain matters between states. These are few examples of affairs of state. ये कुछ examples हैं affairs of state. Now come to Rafael judgment. यहाँ तक clear हो? अब concept समझ में आ गया?
Yes.
Yes
देखो,
sir.
Yes, sir.
देखो अब आ जाओ. अब मैजिक देखो. अब पहला क्या है 123 में? What is the first thing that is happening? There is which record it is?
Unpublished.
Published record.
Unpublished record. Unpublished record, and it is relating to what?
Affairs of the state.
Affairs of state.
Affairs of the state.
Do you know what exactly is affairs of state? How will you determine? आपको कैसे पता कि what exactly is affairs of state? For that, you will have to take affidavit. You will have to take other things, na? For that, you will conduct the examination that has been held in Sukhdev Singh versus State of Punjab, and also in Rajnarayan versus State of UP versus Rajnarayan. ठीक है? So unpublished record relating to affairs of state, and disclosure is allowed only.
With the
Disclosure is
permission
allowed-
of head of department.
Head of department. Disclosure is only allowed by head of department. ठीक है? Now with this knowledge that you have about the section, obviously this section has to be read with which section? Which other section?
162.
62.
So 162.
162 says that whenever you are producing a document, whenever you are ordered a production of a document, you'll have to produce the document and then you will answer objections. That is what it is saying. Fine. But it says that if the matter relates to affairs of state, then the document need not be inspected. This is what 162 is saying. Now with all this knowledge, let's read Rafael. Now let's come to Rafael case. Now, basically in Rafael case, what had happened? In Rafael case क्या हुआ था? देखो, पहले एक 2007 में, I'll give you a briefing of Rafael. 2007 में we needed fighter jets. In 2007, it started in 2007, and Ministry of Defense said that they needed around 180 fighter jets. There was a demand of fighter jets back then. ज़रूरी भी थे. Now, so they started a tender. They started floating a tender. This tender was finally floated, but they could not meet anyone else. So they started floating tender, but they could not meet a reasonable person. In 2015, this tender was modified and 36 fighter jets were asked. A tender was given for 36 fighter jets, specifically Rafale. Now, this tender was given by Dassault. Dassault has agreed with this tender, and there was a communication from Government of India and Dassault. There was an agreement, and in that agreement, Dassault had made a condition. In fact, Government of India had amended the agreement, and Government in India had said that Dassault will require an offset partner. Offset partner will be Indian. Dassault will require an offset partner, and that offset partner will be an Indian partner. Dassault के साथ एक बंदा offset partnership में act करेगा, and that partner will be an Indian. तो अब यहाँ पर आ गया, Dassault took Reliance as an offset partner, and then there was Reliance Dassault company. ठीक है? Dassault was selling, and 50% of fighter jets were to be sold by this offset partner, through this offset partner. अब लॉजिक इसका यही था, so that the money flows through Indian company, so that foreign exchange is maintained. हमारा foreign exchange grow होता रहे, because Indian company है ना, Indian company is earning, so ultimately हमारा GDP grow होगा, GDP तो 4x हमारा maintain होगा. That was the plan. So Dassault ये partner थे, he was like a middleman, और यहाँ से basically Government of India. So Dassault ने 36 दे दिए, and it was going through Reliance Dassault company, and then ultimately it came to Government of India. Now, after a while, someone got to know that Reliance Dassault company is an offset partner in this deal, and Reliance Dassault company, Reliance has never done a defense deal prior. This is their first defense deal, and Reliance company is only a 2 years old company in this market. So people started alleging that there is some corruption involved, and probably there is some pricing issue also, because when we were buying 180 fighter jets, we were getting it at a cheaper rate. But now when we have bought 36 fighter jet, probably we have got it at a 4x price. 4x price पे हमें मिले हैं. So why is that? These were the questions that were asked by people, and they filed a writ. So the moment they filed a writ, Supreme Court, when analyzed all the documents that were produced before it, Supreme Court rejected the first writ. Supreme Court ने बोला कि there is no element of malice in this. We cannot admit it. इसमें कुछ गड़बड़ हमें दिख नहीं रही है. We cannot admit this. One fine day, what happened? There was a big article, and lot of documents relating to Rafael deal were disclosed in many newspapers. The Hindu, Times of India, all these newspapers had disclosed lots of documents relating to Rafael. And these documents were documents belonging to Defense Ministry. Fine. So people came to court again. Now, earlier we did not have the material on record to start an investigation. Now we have sufficient material on record. We have the pricing. Pricing है हमारे पास. We have the prices. We have everything. We have all the documents here. We have the photocopy of the document. We just want you to see these documents. We just want you to consider these documents. The state claimed 123. They said that these documents are privileged. You cannot disclose it. Court took it as a preliminary objection. Court said that, okay, fine. We will decide whether these documents are privileged or not. And then only we will review the matter. Review तभी start करेंगे जब हम पहले decide करते हैं कि ये documents privileged हैं या नहीं. So court asked the defense ministry to give the originals. First, the court asked for affidavits from defense ministry. They were not satisfied with the affidavits. So they asked for further affidavits. They were not satisfied. They called defense secretary in court. Defense secretary 2 दिन तक court में बैठे थे बेचारे. He was cross-examined also. In Supreme Court, he was cross-examined. And court was not satisfied with that also. So ultimately, last thing that the court did was, ऐसा करो आप, you give us the original documents. We have the photocopy, but we just want to make sure that original and photocopy are same. Or we want to see the entire documents we want to see. We just don't want to be the experts of it. So give us the documents in a sealed paper. We will inspect them in camera. Ultimately, the government had to comply with this request. And the documents were inspected in camera. All the professionals of the court were removed from the court. Advocates ho gaye, sare sabko nikal diya gaya. Only 3 judges were sitting. They were inspecting the document. And they ultimately found that the documents were not privileged. They said that this information is not something which will affect the nation. This is about pricing. This will not disrupt the country as a whole. This will not disrupt the functioning of the state. This is about pricing of a jet. If there is corruption involved, so this won't that has to be revealed. This is something not disclosed. This is not disrupting the nature of the state. So in this case, court held that this is not a privileged document and we should proceed with this. Court ने preliminary objection reject किया and court proceeded with the review petition. But ultimately, court rejected the review petition, saying that there is no case of corruption involved here. It seems that we have bought jets at an expensive price because of the time involved. 2007 से 2015 में time भी तो हो गया है. And offset partner is a necessity to ensure that everything happens smoothly. अगर एक डिफेंस डील है कोई ऐसा छोटा मोटा काम थोड़ा ही है. So offset partner is necessary to have a defense deal to run a defense deal smoothly. So there is none of the allegations point out towards the corruption. Therefore, they rejected the review petition, but they ordered production of the document and they held that the document was not privileged. तो बस इतना ही पूरे केस में हुआ है. अब देखो पूरे फैक्ट्स. यहाँ तक क्लियर हो? Till here you guys are clear? Did you understand the entire scenario?
Yes, sir.
Yes, sir.
ठीक है. अब ये आपका this is what has happened in this case. अरे ये मैं क्या देख रहा हूँ? Wait a sec. हाँ. तो in 2005 2007 आपके Ministry of Defense issued tender for the purchase of 126 fighter aircraft. 126 हमें खरीदने थे पहले. But we purchased only 18 and 108 it was decided that they will be manufactured. After extensive selection process, the union selected that Dassault is the best fighter aircraft. Dassault ka Rafale is the best thing that we can have. So in 2015, a price negotiation took place for these 108. Abhi hame 108 खरीदने थे 2015 तक. But then suddenly what happened? In March 2015, Prime Minister Narendra Modi and President of France announced a new deal. They said that we will only purchase 36 fighter aircraft. Okay. Ministry of Defense subsequently announced that the tender of 126 aircraft was withdrawn. ये जो पुराना tender है ये withdraw कर दिया इन्होंने. ठीक है. So now at present we are only at 36 Rafale aircraft. So new deal में एक clause था 50% will be through offset. So मतलब Dassault will have to enter into an Indian partner. Will have to enter into or will have to invest into an Indian partner so that basically goods and services are so that our GDP is growing. So Dassault and Anil Ambani's Reliance Group announced a joint venture which was Dassault Reliance Aerospace Limited. 2016 का ही था. And they invested, in fact, Dassault invested 115 million for offset obligations. ठीक है. तो इसके लिए यहाँ पर इशू आया कि ये बंदा क्यों आया बीच में. What was the need of this fellow? That became a main issue, and therefore 2 issues were raised before the courts. That there was no approval of Defense Ministry when Reliance was added as Dassault's aviation offset partner. अब देखो प्रॉब्लम ऐसा था कि इसमें डिफेंस मिनिस्ट्री हैड नो से. रिलायंस को पार्टनर अपॉइंट किसने किया? हु अपॉइंटेड रिलायंस एज पार्टनर? डिड गवर्नमेंट ऑफ इंडिया अपॉइंट?
यस सर.
गवर्नमेंट ऑफ इंडिया ने कहाँ अपॉइंट किया? हमने तो एक क्लॉज रखा कि ऑफसेट पार्टनर भी होना चाहिए.
Dassault ने किया.
डसॉल्ट ने किया ना. तुम पार्टनर, तुम्हारा डसॉल्ट का पार्टनर है ना. हमारा, हमने कहाँ बोला? Government of India is buying goods from Dassault, but at the same time it is saying कि boss, we will buy goods from you, but we want some Indian to benefit. We want our GDP also to grow, and we want our foreign exchange to grow. So we want you to have a offset partner who will be Indian, who will be an Indian company. अब हमने सिर्फ इंडियन कंपनी बोला, इन्होंने कर दिया पार्टनरशिप रिलायंस के साथ. So how can, why would Ministry of Defense approval required be here? तो ये उन्होंने गाइडलाइंस कोट किए, बट द कोर्ट सेड दैट देयर इज नो नीड ऑफ अप्रूवल इन दिस केस बिकॉज इट इज Dassault's lookout whatever partner they want. It is not government of India who has to see कि now this is the partner, should we proceed, what are the things. So now comes the pricing irregularity. The court held that pricing irregularities nahi hai, it is because the time has elapsed, that is the reason. So court found that no irregularity in the decision making process was there. There was no pricing or selection. This is the first decision. जैसे ही पहली बार writ इन्होंने move की, the court said that there is no irregularity in decision, there is no irregularity in pricing, there is no irregularity in selection of offset partner also. So court ultimately rejected their application. Then another review petition was filed. अब रिव्यू में यहाँ पर रिव्यू इसलिए किया क्योंकि there were certain reports which were published in Hindu and Caravan. Attorney General objected to rely on these documents. He said that these were stolen from Ministry of Defense and they are privileged under 123. किसी ने चोरी कर दिए ये documents and they are privileged under 123. Now, defense ये था कि petitioner ने defense किया कि there cannot be privileged because these documents are already in public domain. Public domain में कैसे हैं? Because इसने तो वो कर दिए ना, हमारे newspapers have already published ना. Newspapers have already published. So they are already public. So you cannot say that they are unpublished. So you can rely upon them. Newspaper ने already publish कर दिए ना सारे documents. All the documents have been published by newspapers. So this was the contention of the petitioners. They are already in public domain. सारे documents public domain में, newspapers have already published. What is the requirement of it? Court dismissed this preliminary objection. ये objection 123 वाला. Court dismissed this preliminary objection. Court said that these records are not privileged. ये सारे records privileged नहीं है. कोर्ट ने dismiss कर दिया. कोर्ट ने ये held किया कि these records are not privileged in nature. Fine. Reasoning, why they are not privileged in nature? They don't relate to affairs of state. Not relate to affairs of state. They relate to a deal made by state. ठीक है? They are not privileged in nature. Simple as that. And court ने production allow कर दिया इन documents का. This is your 123. Clear? यहाँ तक clear हो?
Yes, sir.
Yes, sir.
Yes, sir.
With this we are done with 123. Let's call it a day. कल मुलाकात होती है आपसे. Yes, Nuri, बोलिए.
So एकदम last slide please, और I
हाँ
have
जी।
a question to ask. सबसे last slide.
किसका, पीपीटी का या व्हाइट बोर्ड?
Sir white board.
व्हाइट बोर्ड का, ये वाला।
सर ये वाला तो सर नहीं सर, एकदम लास्ट वाला
ये
जो
वाला
था। हाँ सर, सर ये जो 162 आपने लिखा सर, 162 में किसी को भी बोल सकते ऑब्जेक्शन, मतलब नहीं होगा उनको, है ना सर?
किसी को भी बोलोगे प्रोड्यूस करने के लिए डॉक्यूमेंट, तो उसको प्रोड्यूस करना ही पड़ेगा डॉक्यूमेंट, और उसको अगर ऑब्जेक्शन है प्रोडक्शन से, कोई भी ऑब्जेक्शन, कोई भी, जरूरी थोड़ी 123 में ऑब्जेक्शन है, बहुत सारे और ऑब्जेक्शन भी हो सकते हैं ना, कोई भी और ऑब्जेक्शन है तो वो ऑब्जेक्शन वो रेस करेगा और कोर्ट डिसाइड करेगा कि ऑब्जेक्शन सही है या गलत है। ठीक है
सर, सर 122 से लेकर एक क्वेश्चन था सर,
पूछिए।
आपने बताया भी, बट मुझे 2 पॉइंट्स में क्लियरिटी नहीं हुई सर। पर्सन थर्ड पार्टी का कैसे मतलब एक्सेप्शन में आ गया, और सर
थर्ड पार्टी की प्रिविलेज उसमें ही है ना, सेक्शन 122 में आ जाओ, पहले आ जाइए सेक्शन 122।
जी सर।
No person who is or has been married. No person who is or has been married shall be compelled. इसमें थर्ड पार्टी के ऊपर है कोई रिस्ट्रिक्शन?
नहीं सर।
जो बंदा जो जिसने शादी की है या नहीं की, या कर चुका है, वो कंपेल नहीं होना चाहिए, या उसको अलाउ नहीं करेंगे। हम बोल रहे हैं कि थर्ड पार्टी को तो अलाउ कर सकते हैं ना, थर्ड पार्टी इसमें आ ही नहीं रहा
सर तो मतलब ऐसे इन्फरेंस निकाला कि थर्ड पार्टी को मतलब एक्सेप्शन है।
हाँ।
और सर कंडक्ट इसलिए क्योंकि यहाँ पे कम्युनिकेशंस लिखा हुआ है, इसीलिए कंडक्ट को एक्सेप्शन में डाल दिया ना सर?
हाँ करेक्ट।
बाकी तीन तो है एक्सक्लूसिवली इन द सेक्शन,
बाकी तीन
इसीलिए।
तो हैं एक्सक्लूसिवली, करेक्ट।
थैंक यू
चारों
सर।
पांचों ही एक्सक्लूसिवली हैं, अगर देखोगे तो ध्यान से, अगर हम देखेंगे तो पांचों ही हैं।
ओके,
उसको सिर्फ
थैंक यू
कोर्ट
सर।
ने अलग अलग रुख में बताया है।
ऑलराइट सर, सो हैप्पी एडवोकेट्स डे।
हैप्पी एडवोकेट्स डे एवरीवन।
थैंक यू सर।
यस अनिंदु बोलिए।
गुड इवनिंग सर।
Good
सर
evening.
ये वाला स्लाइड दिखा दीजिए सर, स्टेट ऑफ पंजाब वर्सेस सुखदेव सिंह, जो व्हाइट बोर्ड वाला।
व्हाइट बोर्ड वाला, व्हाइट बोर्ड में मैंने, अच्छा वो,
मतलब उसमें थोड़ा सा हमने लिखा था।
हाँ ये वेट, कहाँ लिखा था? यहाँ पर लिखा था क्या, ये वाला हाँ ये
सर वो मैगजीन क्या थी बता देंगे प्लीज सर? मैगजीन
सोलस पॉपुलस एस सुप्रीमा लेक्स, सोलस पॉपुलस एस सुप्रीमा लेक्स। ठीक है, स्लाइड अपलोड करा दूंगा।
ठीक है सर। सर एक चीज ये पूछनी थी सर, हमने जैसे विटनेसेस करे सर, हमने होस्टाइल विटनेस नहीं किया, वो अभी करेंगे क्या?
वो मैं जानबूझ के 154 के साथ ही पढ़ाऊंगा।
ओके।
मैंने वो छोड़ रखा है, इसलिए मैं उसके साथ ही पढ़ाऊंगा, यहाँ पर कंफ्यूज हो जाऊंगी। यस
सर अटॉर्नी वाला सर
नहीं,
154 के साथ।
हॉस्टाइल 154 दूसरा है, 154 यहाँ।
ओ सर।
ठीक है। यस
सर जैसे आपने बताया एफिडेविट हो गया, फर्दर एफिडेविट हो गया, तो सर इसमें भी कुछ ऐसे है कि सिर्फ ये काम जो मतलब स्टेट अफेयर्स की बात हो रही है, तो सिर्फ सुप्रीम कोर्ट ही देख सकता है, या कोई भी हाई कोर्ट या कोई भी कोर्ट?
कोई भी कोर्ट, मैजिस्ट्रेट भी।
ठीक है सर,
कोई भी।
थैंक यू सर।
ठीक है। यस दीपांकर बोलिए।
गुड इवनिंग सर।
गुड इवनिंग बोलिए।
सर एक तो वही सेम जो हनी ने पूछा वही क्वेश्चन, मतलब वो किसी भी कोर्ट को पावर है,
किसी भी कोर्ट के पास पावर है, जिसके पास प्रोडक्शन ऑफ डॉक्यूमेंट्स ऑर्डर करने की पावर है, उनके पास ऑब्जेक्शन डिसाइड करने की भी पावर है।
लाइक अभी कोई ट्रायल चल रहा है वहां पे, मतलब पुलिस का भी कोई, तो मतलब वो कर सकते। और दूसरा सर ये जो 122 में सर आपने बताया सेक्शन क्रिमिनल प्रोसीडिंग में, सर लाइक ये केस है उसमें सर जो वाइफ है ना, उसने सर अपने फादर इन लॉ और मदर इन लॉ और ब्रदर इन लॉ इन सबको वो उसमें किया है, एलिजेट किया है 498 है, हस्बैंड को नहीं किया है। और हस्बैंड जो एफआईआर का वर्जन है सर, उसमें हस्बैंड और वाइफ दोनों ने मिलके लिखा है कि वो, उसका हस्बैंड भी कह रहा है कि हाँ मेरे फादर मेरी वाइफ को परेशान करते थे इस तरीके से।
तो इस पे 122 लगेगा आप बोल रहे हो?
हाँ मतलब उसमें अब इनका सर अगर फर्दर प्रोसीडिंग जाती है
122 कैसे लगेगा? इफ देयर इज अ हस्बैंड अगर वाइफ को प्रोसिक्यूट कर रहा है, वाइफ अगर हस्बैंड को प्रोसिक्यूट कर रही है, तो 122 नहीं लगेगा ना। अगर आप वाइफ अगर हस्बैंड के खिलाफ केस फाइल कर रही है, चाहे सिविल हो क्रिमिनल हो, तो 122 वहां पर प्रिविलेज नहीं आएगा।
नहीं, यहाँ पे वाइफ ने अपने फादर इन लॉ के अगेंस्ट किया 498 है।
हाँ,
सो इनका जो मतलब इनका जो प्रिविलेज्ड कन्वर्सेशन है या कम्युनिकेशन जो आपस में हुआ
वो
है,
ये 498A वाले केस में नहीं यूज कर सकते, बट अगर FIR कोई है, अगर हस्बैंड ला रहा है तो उस पे 122 अप्लाई नहीं होगा।
अच्छा,
ठीक है, तो ऐसा नहीं है कि दूसरी कोई चीज, अगर दूसरा कोई केस आप हस्बैंड ला रहा है या वाइफ कर रही है, उसमें 122 अप्लाई नहीं होगा, बट किसी और मतलब किसी और केस में वो कम्युनिकेशन हस्बैंड और वाइफ का यूज नहीं कर सकते।
नहीं कर सकते।
नहीं कर सकते।
ओके ओके सर,
ठीक है,
थैंक यू सर।
सर
यस
सर
समीक्षा।
सर एक क्वेश्चन था, जैसे
जी।
हम बोलते हैं अदर और अनदर, तो सर ये अनदर में थर्ड पर्सन इंक्लूड होने की बात हो रही है ना, थर्ड पर्सन की बात हो रही है ना?
हाँ, थर्ड पर्सन।
ठीक है।
यस समीक्षा।
Good evening, sir.
गुड इवनिंग।
So, the moment we started with the section 123, I lost my internet connection. So, I just rejoined it when we were discussing some things on like PPT. So, can you please brief it up like just so that I can, when I watch the recording for that part, I get something?
We started with unpublished. We started with this. First, I explained you what exactly 123 means.
Yeah, this slide was done. I wrote this down, but what happened next, I don't know.
After that, I told you in what cases, how will you claim this privilege? What are the aspects of claiming this privilege that we dealt? कि कैसे आप ये privilege claim करोगे? That is what we dealt.
So I'll go through the recordings
Can
once.
court, we discussed can court review this privilege? So the answer was yes, court can review the privilege. Okay.
All right, sir. Thank you.
सर पीपीटी अपलोड होगा ये LMS?
हाँ, PPT अपलोड कराऊंगा। ठीक है, चलिए, चलो guys, see you guys tomorrow. Bye everyone. Bye everyone.
Thank you, sir.